Today, we're going to talk about PAGA, which is not a summer cocktail, the Private Attorneys General Act. Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. Wow, it's starting to get hot in Sacramento. June is coming. I don't know where you are in the universe or the world. It could be winter where you are. I wish it were winter here, but it is not winter. It is summer, and it will be okay. We will all live. I like to say my sort of ancestry is Irish and Scottish and English, and I like to say I'm not a good heat exchanger. So I like it when it's cooler. Anyway, enough of that. I want to talk about the Private Attorneys General Act. Now, PAGA. We have talked about this a lot, and something dawned on me. I was talking to one of our lawyers, Elena, the other day, and she said, Jen, have we done an article on how to deal with the amendments to PAGA and take advantage of these provisions that allow for lower penalties if the employer has actually taken some remedial measures? And I said, well, yeah, we must have written something. Well, we hadn't. We have now, by the way. But it also dawned on me, I haven't even explained to all of you what really is PAGA. And I think we need sort of a back to the basics so that you can really understand what we're talking about. And I think it's critical for every California employer to understand in depth what this law is and then how you should be interacting with it. Okay, so first of all, most of you have heard of PAGA. The fact of the matter is, many employers have been sued for PAGA violations. They have found themselves in mediation because something was wrong in a wage hour way, right? Remember that PAGA is all about wage hour compliance. So it might sound simple, 4 little letters, PAGA, but understanding what it is, how it functions, and how it can affect you can be very challenging. It's complex, okay? So first of all, the law was passed in 2004 by the state legislature, and the purpose was to assist the state in enforcing the California Labor Code. The state didn't have enough folks to do that on their own, meaning the folks who worked with the Division of Labor Standards Enforcement. So PAGA essentially deputizes individual people, not the government, to file lawsuits against their employers. It can be a current employer, it can be a former employer, and they're allowed to recover penalties that were previously only recoverable by the state. Okay? So, to make this clear, the state used to be able to come after you for penalties, all right? And then in 2004, the legislature said, well, gosh, we don't have enough people to make that happen. So we're going to let individual employees get the same penalties that we were able to recover. All right. Now, by definition, PAGA claims are brought as representative actions. That means that the person bringing the claim is seeking to represent other similarly situated coworkers. And the term that's used in the law is aggrieved employees. Okay, so other aggrieved employees, other employees who were subject to the allegedly unlawful act or unlawful policy or unlawful practice. Now, a representative action isn't the same thing as a class action, which you may have heard of. You know that you might get these little cards or little letters saying, oh, you're a member of a class action against Macy's because their policies about interest rates were not properly noted in your cardholder agreement. If you want your $1.27, please fill out this form. Okay, that's a class action. PAGA is a little bit different. There are different proof standards and different ways of administering a PAGA claim. There are a ton of PAGA claims that are made every year. And the way the claim starts is that they have to file a notice with the state's Labor and Workforce Development Agency. We call that the LWDA. The notice is a notice to the LWDA, okay, that says, hey, I want to bring a PAGA action against ex-employer, they have to specify the sections of the labor code that they claim were violated and provide sufficient facts and theories to support each alleged violation. Okay? Now, this notice can be submitted on the internet, but you also have to serve it on employers via certified mail. I don't love certified mail because it takes longer for something to be delivered and the individual could just decide they're not going to pick up the certified mail. But when the law says you have to use certified mail, you have to use certified mail, okay? So when you get this notice, you'll be getting a notice via certified mail. The notice is in the form of a letter that's directed to the LWDA. So the letter itself is going to identify the name of the employer and the alleged violations. Now, you have a limited time period during which you can decide, okay, you're going to cure or take other steps to prevent the alleged violations. And you're also going to think about who needs to be notified about the letter. Obviously, every employer needs to understand if a letter like this comes in, they've got to deal with it right away, okay? Because there are very definitive time frames and time limits that you have to take action. Now, once the notice is filed with the LWDA, they will decide whether they want to investigate the employee's claims as described in that letter or allow the employee to proceed with a lawsuit. Typically, if they're not going to investigate, they just don't respond. Okay, so they're just going to let the notice sit there. If they haven't taken any action after 65 days, then the employee can file their private lawsuit under PAGA in court. Now, historically, the LWDA did not investigate hardly any of these letters. So they would just not respond, and within 65 days, the employer would generally receive a lawsuit, all right? Since PAGA was overhauled last year in 2024, it does seem like there's more of an effort by the folks at the LWDA to investigate these notices. And by effort, I don't mean they haven't used effort before. What I mean is they didn't have enough people. So they've hired some more people and they've got more resources and they are interested in investigating many of these claims. Okay, now, one of the things we've talked about is that PAGA allows you to address certain violations during that notice period, that 65-day period, thereby avoiding the litigation and the penalties that are related to those labor code provisions. The key date for you to know is June 19th, 2024, because that's the date that the PAGA reform legislation became effective, and it really expanded the range of violations that can be corrected. So right now, as of the date of this podcast, violations that could be cured include those related to overtime, meal and rest breaks, minimum wage, wage statements, business expense reimbursements, and a bunch of other things, all right? Depending on your size, you may be able to submit a cure proposal to the LWDA before the lawsuit is filed, and that's the case whether or not the LWDA decides to investigate. One of the things that I think is interesting is that these employer proposals are treated as confidential information. They can't be used to substantiate any claim or as an admission of liability, okay? But if it's accepted, if the proposal is accepted, the employer's confirmation that the cure was completed and the supporting records and documentation have to be shared with the employee who filed the initial PAGA notice. So that's an interesting little twist that a lot of us don't like. Okay, now, if you don't want to do that, if you don't want to submit to the LWDA a pre-lawsuit cure proposal, you can request an early evaluation conference when you initially appear in the case. If it's granted, the company's going to have to submit a confidential statement saying what items that it intends to cure and dispute. Remember, this is going to be shared with the plaintiff's counsel, and a neutral evaluator is going to hold that conference to try to assess whether any of alleged violations occurred and whether any of the claims can be settled, okay? Now, keep something in mind. Although you can potentially avoid PAGA litigation by curing these violations, this is a big strategic decision that you don't want to take lightly, all right? There are very strict requirements contained within the PAGA amendments regarding how to successfully cure a violation, and those violations include things like the payment of unpaid wages, liquidated damages, and interest. And the decision to submit a cure proposal typically requires a pretty high-level analysis of the employee's time and payroll records. And I mean employees as a group, okay, to calculate how much is owed to them and what might be covered by the proposal. So you can do all that before the lawsuit is filed, okay? Now, once the lawsuit is filed, the plaintiffs, the people who are suing, are now stepping into the role of the LWDA. So they're now going to sue to enforce the labor code and recover the applicable penalties. As I mentioned earlier, PAGA cases and class actions are similar, but there are important differences. For example, the plaintiff in a PAGA action doesn't have to certify their claims prior to trial, but in a class action they do. So that's one important difference. One similarity, of course, is that both PAGA settlements and class action settlements are going to be subject to court approval. So the 2024 amendments really are focused on reducing the civil penalties that are owed under PAGA. It really also seeks to level the playing field for employers by reducing what we call technical violations, like the name on the wage statement wasn't exactly right, but there was no confusion about who they were talking about. The sort of catchphrase in the PAGA violation is all reasonable steps. The employer wants to show that it took all reasonable steps to comply with the labor code before or after the PAGA notice was filed, okay? The 2024 amendments to PAGA also require that the plaintiffs personally experienced each labor code violation for which they seek penalties, all right? And it gives the court the discretion to limit the scope of PAGA claims and the evidence that's going to be presented at trial, okay, because it becomes unmanageable. So what can you do to prevent a PAGA claim? Well, you can take various steps to mitigate your risks, and the recent amendments and the rewarding of employers for making good faith efforts makes this all the more important. So if you're not doing these things, you want to talk to the folks internally who can make it happen and figure out what they want you to do. So you should conduct regular audits of time and payroll practices and records to ensure employees are being properly compensated and receiving state-mandated rest breaks and meal periods. Those are, of course, only for non-exempt employees, but these rules apply to all employees. Regularly review your policies and procedures to ensure compliance with the California Labor Code. Conduct periodic trainings with supervisors and managers about company policies and relevant provisions of the California Labor Code. And then make sure you implement corrective actions if you've got a problem. All of these things are very important to be able to take advantage of that all reasonable steps exception. So I know this one was a little dry, but it's really important for you to understand what PAGA is. Please reach out to your employment counsel if you have questions, and make sure you have assigned somebody in your workplace that if they get one of these LWDA letters, they respond right away. Thank you for joining me today, everyone. I'll see you next time. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others, post about it on social media, and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.